And for our friends from OTLA, let's start with 3007. So we don't.
Friend, yeah.
Friend, oh, all right. Well, you're it. Richard, you want to introduce yourself to everybody?
Thank you, Chair Shadoway. Richard Lane, I do represent the Oregon Bylaws Association. I practice mostly medical negligence, wrongful death, personal injury. I've been doing that for way many years.
Well, you were doing it when I was in the legislature, so it's been a long time. All right, Richard, so that we don't torture you with small estates.
Oh, wait a minute.
Yeah. Let's go ahead and start with House Bill 3008, and I have, and the committee has, email from Art Towers about OTLA's concerns, and then a response from Shannon. Shannon, thank you for that. So we have that before us. I guess, Richard, let me turn it over to you and ask you to maybe articulate Art's concerns in the email.
Thank you, Chair Shadoway. First of all, I'd like to say I apologize for the sort of the late appearance. I know the work group has been working quite a bit on this. There was some communications earlier back, and there were concerns raised, and the report back was those were taken care of and off the table, and there was nothing going forward. I think that's where there was a bit of a breakdown. And we did see a bill, and our legislative committee got eyes on it and went, whoa, there's quite a bit here that's happening, and it raised some concerns amongst our members. And so I've got those sort of pulled out or teased out, if you will. But I guess I wanted to start with sort of just an overview of where I think that the disconnect might be. And that's in the real prosecution of a wrongful death. And now I understand through this bill, we're gonna make it very certain we're including survival action, which you labeled it a different way, but what I'm familiar with.
Right.
Is survival action. So you're gonna tuck those in and make sure that there's no doubt as to the approval process for those survival actions. I'm just going to talk about the two of them, assuming that goes forward,
Yeah.
that they apply both. So my comments are addressed to both. If I hang to the wrongful death, it's just out of
Sure. No, that's fine.
Oftentimes, after the personal rep has been appointed, you move into prosecuting the action. You have discovery, you have all sorts of experts, you take depositions. Eventually you're going to get to the point where there may be an opportunity to talk about a mediation or some sort of a settlement negotiations, or you're going to proceed to trial. And sometimes you start trial and things just take a turn, and suddenly 3 days in, there's a new discussion, and maybe there's some resolution in the midst of a trial. You've already got a jury in there. In either situation, the parties have got to have the certainty to be able to execute a settlement agreement. It's got to be a handshake with the defendant, often the defendant's insurers. You've got to have the outlines of what is agreed to resolve the case. And that's critical for taking the next steps of whether there's a private healthcare insurer that you've got to negotiate with as far as reimbursement of medical expenses that might be in the case. They want to know, what did the case settle for? That's a critical piece of information. Oftentimes you've got to deal with either a state or federal agency, perhaps the same thing is required. But in a death case, what typically happens is that the mediator writes up an agreement that says the parties have met and they've settled the case for this, and they're going to pay this when, and they're going to do this, or any other conditions of the settlement agreement. And both parties are going to sign that, and everybody goes home with an agreement. In the case of the trial court situation, I've got to be able to tell the judge, last night down in the restaurant, I met with defense counsel, and we've reached an agreement, and you can send the jury home with our thanks for participating in the case. He can it takes off the docket, closes up that piece of the action. So what we typically have written in, whether it's a mediation or it's an agreement with, is that there's an agreement, a settlement agreement has been reached amongst the parties, subject to court probate approval.
Right.
And so when we look at what you have in current 3008, that sort of turns it on its ear. You're actually, and I can start looking at specific language, and I'm starting on page 1 in section 3, lines 27. I'm going to speak to the ORS 114.305 in a moment, which is not standing language. But you're actually saying that the personal rep may not enter into a settlement agreement. You're prohibiting that. How can I proceed to resolve the case without the ability to enter into a settlement agreement? How can I tell the trial court we have a settlement agreement when I can't enter one?
You just, if I can just interrupt,
Yeah.
in your own telling of it, you said, subject to approval.
And that's what typically
Right.
takes place. But this says I can't enter into a settlement agreement. It doesn't say subject to court approval, it just outright prohibits it. That's different than what I just explained is the
Okay.
practical application.
Okay.
Understanding-
Yeah.
We're understanding.
Yeah, and I think,
Okay.
we're not that far apart.
I just, there was a quizzical look there, and I just.
No, I just want to make sure we capture that you acknowledge that the settlement in a wrongful death proceeding is ultimately subject to the approval of the probate court, regardless of the handshake in the restaurant during the trial.
That regardless is kind of critical from where I sit.
But I mean, but it is
But it is
subject to approval. Right,
No
okay.
question, no question. But the language that
All
you're
right.
chosen to use may not enter into the settlement agreement. That shuts it down. That's not
Okay,
subject to court approval. That is a prohibition of being able to enter into the agreement
Then
to
let-
resolve the case.
let me just stop there. And I think we're not, as a committee, different in intent from what Richard is describing.
I completely agree.
Yeah.
So can I just propose though changing to the wording?
Well, I want to finish this conversation, but I wanted to make sure that we acknowledge that at this point, there's not a great divergence between what you're describing and what our intent is here.
And as we go through this, Chair Genoway, I don't raise anything about the intent of the work.
Oh, okay, the
My
language.
focus is
Sure.
the language
Well,
and its application
and that's,
in real
sure.
life.
Okay, that's a good marker, so keep going.
Okay, so then that continues, along that line onto, the second page of the bill. And on line 3, you've chosen to say that the probate court authority is now going to be limited to determining the adequacy of the proposed settlement. If you look at 30.070, which is the approval power of the probate court, there's no such limitation as to what the probate court, in its discretion, can ask, can try to find out, can examine. It's unlimited. Your chosen language shall determine the adequacy now is calling out the only thing
Okay.
the probate court in its authority that it has under 30.070 could ask about the settlement or make a decision about it. So there's a little bit of concern about that limitation
Okay.
that you've now chosen to put in that language. You move down and then you start into the subsection 2 and this declaration process. And the declaration process I'm familiar with because a lot of these sub-factors are used in the supplemental local rule in Multnomah County. So I've been familiar with having to submit the declaration to solicit the approval of the probate court. But you've got more factors in there than what's in the SLR. And I don't know where those particular factors came from, but number J, stating that the attorney has independently evaluated the interests of the estate and the beneficiaries. That's a violation of my professional responsibility. I have one duty and one duty only as representing the personal representative of the estate. I cannot, and there are a number of cases, discipline members of the bar for failing to adhere to that prohibition. I cannot look to a beneficiary and say, that interest is X or that interest is Y. That's a conflict of my sole and exclusive duty to the personal representing the estate. So that factor not only is not Oregon law, but actually violates the professional responsibility duties that I have and runs counter to a number of Supreme Court disciplinary opinions.
Okay.
The RPC still has that conflict rule in place. I'm used to the old disciplinary rule, not the RPC automatically. Then you move down to the L, I think it's a little L, stating whether the attorney has consulted with the Department of Human Services to determine if liens exist under 416.540. And again, that's not a requirement that I'm aware of in Multnomah County. It's one of the factors in their SLR. So that's a new one that came from someplace. I don't know where.
Yeah, I don't know, maybe for me.
Okay. I don't know you.
Probably,
Ms.
yeah.
Mills,
I'm the policy analyst for the Department of Human Services, and I work with the Personal Injury Liens Unit.
Okay, so we suffer the same problem at this juncture in the real practice as to, I don't speak for any of the beneficiaries or any of the interests that might be there. I have one responsibility only, and that's to the PR, which is really a fiction. It's a person has been designated to proceed with the wrongful death and not in the capacity that they may hold as a beneficiary somewhere down the line. So there's the...
How does checking to see if we have a lien create a conflict of interest?
Because I don't represent any of those individual beneficiaries. So let's just say...
I'm not talking about beneficiaries. I'm talking about, we have a lien on the proceeds of the settlement or the judgment, and it would seem to me that would be an essential part of the personal representative's duty, is to see if there are any liens on it.
And the lien that you're speaking of is created by what mechanism?
By a statute.
No. I understand the 416 statute, but who are you saying you have to have this conversation about?
Huh? I'm sorry.
Well, I'm being asked to affirm or declare.
Whether you check with us whether we have a lien.
And I've consulted, and I'm supposed to ask what question?
Do you have a lien?
As to who?
It's against the estate. It's against the proceeds of the judgment and the settlement. So it's like, do you have a lien against this?
Do you, DHS, have a lien in this case?
As to the decedent only.
Yes.
What?
As to the decedent only, that's the
Yeah,
one question.
Well, it's the estate.
Well, I mean, the estate.
Well, once again, what difference does it make? You're just asking, do you folks have a lien?
And the person's going to respond to that question of who's the person that you're asking about.
We're gonna say, yeah, we're gonna wanna know who the deceased individual is.
Okay, so all I would then ask is that it talks about having a conversation about the decedent only.
This is a wrongful death case, right?
But the wrongful death case, creating the fund that's subject to the probate court approval does not constitute any award to anybody, including the decedent's estate at that point. It's to the surviving spouse and the various children or stepchildren as defined inside the wrongful death statute. So all I'm trying to figure out is the consultation that you're asking me to affirm to do as a duty refers to whom?
We're asking the attorney to state whether they consulted with us to find out whether we had a lien on the judgment or the settlement proceeds.
Let me ask,
I don't
Richard, what's 416.540?
It's about, I just looked it up.
That's the third-party personal injury.
Okay.
It's a lien upon the amount of any judgment in favor of a recipient or amount payable to the recipient, and that's recipient of
aid
Of
from,
aid, yeah, aid,
Medicaid.
right, yeah,
And TANF.
yeah. So it's a lien upon the amount of a judgment in favor of the person who received aid, yeah.
So your point, Richard, is that the wrongful death proceeds are payable not to the estate, but payable directly to beneficiaries named under the wrongful death statute. And so are you saying that 416-540 doesn't apply?
I'm saying that 416 refers to a lien to a recipient.
And that recipient is the decedent. The decedent received, before
Right,
the
and the
decedent
lien-
died, the recipient, what the decedent received was at OHSU receiving all of this care, and that was a Medicaid claim that was made by OHSU to get to DHS to reimburse them. So DHS now has a lien on the proceeds of any case that's brought, any judgment or settlement or compromise that's brought as a result of those particular injuries to that decedent.
Well, Gretchen, let me ask, because the statute says a lien on amount payable to the recipient for all assistance received by the recipient. And Richard, as I understand, your point is that the wrongful death isn't payable to the recipient.
It may or it may not be.
Well,
Well, it's not, because they're dead.
yeah, they're dead.
Yeah.
Right. So, okay, now, Jennifer.
And the other thing is, in the wrongful death statute, it's very clear that the deaths of the decedents are not payable out, it's not an estate proceeds where the deaths of the
Right.
decedents are paid. So it seems to me that this L should be limited to personal injury survivor actions and not even apply to wrongful death action. Am I wrong about that?
Well, that's, I'm interested in teasing that out. John, you read it? You don't know anything about wrongful death.
I don't know anything about this. I got a partner who lives and breathes it. But, personally, I think it's all a bunch of BS, but my question is, why is sub 2 aimed at the lawyer to begin with? You know, when I'm a lawyer in a probate, I represent the PR, and I don't represent any other person in the room, and I don't want to have any obligations to any other person in the room. We've been jealously guarding that. That's the way the world works. So why here, maybe wrongful death's a different world, but why here do we impose affirmative obligations on the lawyer to do anything?
Shannon, do you want to,
Yeah,
let's ask the wrongful death lawyer in the room.
Yeah, I'm just trying to help
Yeah,
here.
yeah.
So this declaration is required under the uniform UTCR currently. And then a lot of counties, specifically Multnomah County, has broken down the declaration that needs to be included with the petition to approve settlement. And so this language started out just mirroring Multnomah County's requirements, and then, in meeting the interest of the committee, there were some additions made to that. So specifically, this lien provision, my understanding is that 540 is only the lien that's incurred from the date of the injury to the date of death. And so that is.
No, it's from the date of the injury to the date of settlement.
Or date of settlement,
Yeah.
date of settlement, and so that has always been.
Well,
done
payment of
to,
settlement, sorry.
attached to the, settlement proceeds or the judgment. And a notice to DHS has always been required by the court. So they have historically waived the information to heirs and devotees in these types of proceedings, even Marion County. However, they've always required notice to DHS. That is routinely provided, and it is, I think, exposing the personal injury, wrongful death attorney to liability if those aren't being paid before the funds are distributed. So I don't see a situation here where settlement proceeds would distribute out prior to paying the Medicaid lien. I don't know if that addressed your concern.
Well, I don't know. Chapter 416 also makes a statement referring to personal representative. I don't recall the exact area in the citations. I mean, I came here and this is something that's being thrown at me cold. Second of all, we pay medical expenses that are related to the injury, those have to be paid under Chapter 30 provisions regarding wrongful death. So, and I fail to see how checking to see whether we have a claim or a lien, and telling the court that you check creates any sort of burden or liability or conflict of interest for the attorney. You're just simply saying that you check.
Well, why does the lawyer have to do that?
Well, I don't know.
Why doesn't the PR certify that? The PR's job, not the lawyer's
Okay,
job.
fine, you wanna make it the burden of the PR, that's okay by me. My problem is, of course, is my practical experience is that the PR never does. And the attorneys, of course, never want PRs to do anything without the attorney, you know, overwatching it and basically doing it for them. Because they're afraid that their PR is going to do something that they don't want them to do.
Don't you get notice of the penalty of the claim?
Should, but I don't.
Well, lots of times, no. That's why we've had to end up bringing lawsuits against lawyers and getting judgments against lawyers, because they pay this out and they don't let us know. And, I mean, I have obtained judgments against attorneys for violating the statute.
And we're starting to go after the insurance companies when they don't pay us.
So, I mean, this is with regard, if your focus is on about to whom is this directed, it is the decedent. So it is about the decedent. The lien is for assistance that was provided to the decedent. That's the person that we're talking about.
Which is the legitimate expense of the wrongful death action.
And then you're calling and certifying, yes, there is a lien, no, there is not.
So let me just kind of capture this. I think, I get a sense that we're not strongly attached to J. And
It's in the SLR.
is it in the SLR?
Yeah, it's written differently.
How is it written in the
The
SLR?
SLR says that they will evaluate the interest of the injured party, whereas our bill says the estate of beneficiary.
Interest of the injured party?
It's because it pertains to both personal injury and wrongful death.
That's a survival action requirement.
That's right, so, I mean, I think for J, at a minimum, should definitely just be a state, not a state and beneficiary, but I agree with Secretary on the conflict of interest issue for that provision.
Okay.
Well, I don't think we should conform the statute.
No, to the SLR, I understand.
Validity.
Right, yeah. Are those,
And how a court can require that.
looking at the text, are those the three main issues you have with the text, Richard?
The other one was more of a curiosity, and that has to do with, section ten, starting at the top of page 5, and this is the valuation that, you're going to put the value of the personal injury and or the wrongful death claim for the purposes of calculating a fee
For the PR fee?
for the PR.
Yeah.
That has never been the case, and I just was curious, I guess, about why you're going to do that. Sometimes these are in relatively short term in a client's trust account, for disbursements. Sometimes the amount may not be all that significant if there's limited insurance proceeds, available under the circumstance. It just was more of a curiosity.
So there, if you don't mind.
Yeah, Shannon, please.
In 2009, there was actually a case on this. This is where we drew in this, provision, but some Brown v. Happy, and it says that a wrongful death claim should be included in calculating the personal representative fee. So that's why we decided to put it in. In practice, I don't see our personal representatives take the fee very often. I know at least when, especially the professional ones, are being compared now, or at least our, it is already law, that's why we were bringing it in, but, in practice, I don't see it
Okay.
happen very often.
So there we're codifying case law.
That's right.
Okay, so let's go back to section 3, and John,
Weston, this is our correction to,
no, the correction means the, Steve,
yeah, that's.
no, that's in 3006.
Okay, so we're just sort of parroting that here.
Yeah, I mean, when all three of these bills move,
What now?
Marisa will merge the amendments to the,
Just a,
right?
Somebody was.
Well, okay, yeah.
just a drafting question from Marissa. It's necessary to parrot all of this here? We can't just cross-reference?
Not in a bill that hasn't passed.
Cross-reference, I mean, if it's done in another bill, then it will, if it becomes law, then it'll become law. If it's made law in two bills, then, it won't happen twice, it'll just, those bills will be combined to make it happen once. But you can't reference another bill that.
But the same section being
Yeah.
amended in two different bills?
Right.
Yeah, then
Okay.
they get.
Yeah.
So, Richard, I think the first one is easy because I think it doesn't affect our intent at all. And has anybody got any language yet? Jennifer?
Oh, if you just change it in line 28 on my
Yeah.
If you just claim, it says, wrongful death claim, notwithstanding, the party to a personal injury claim or wrongful death claim may enter into a settlement agreement subject to the approval of the party.
Right,
And that eliminates
yeah.
the timing.
And that harmonizes with 30.070. You good on that, Richard?
I think so.
Okay, I understand. Yeah, well, the point is, we would mirror the same subject to approval of the court. So it's not a prohibition, it just acknowledges that the settlement is subject to approval by the probate court. So it's not, instead of a prohibition, it's a permission. May, subject to approval of the court, the probate court, enter into a settlement agreement. Yeah.
Can we take a moment then about the notwithstanding?
Yeah, tell us about that.
Well, the legislature in 114.305 sub 20 gives the personal rep the authority currently to prosecute claims of the decedent, including those for personal injury or wrongful death. So the settlement process, if you will, is part of that prosecution power inside of it. So the notwithstanding causes sort of a conflict. You're reading out the existing law in that sub 20 about the ability of the personal rep to prosecute claims of the decedent, including those for personal injury or wrongful death. So why do we?
Yeah, okay. Where did that notwithstanding language come from? Do you know, Marissa? And I don't think it needs to be there.
I think it's without, but there.
So I guess the first,
Yeah,
the parties to a personal injury claim or wrongful death may enter.
yeah. Settlement agreement, subject to approval of the probate court. And then the rest of the language is fine.
Okay.
All right? All right, let's talk about J then on line 19.
We have one other point.
Oh.
That adequacy,
The adequacy.
Oh, yeah, sorry.
3 on page 2.
Yeah,
If you look at 30.070, personal rep of the decedent with the approval of the court. So that approval is unfettered in any way. And now you're telling it, I mean, you read that, they have only one discretionary duty, and that is determine the adequacy. So 30.070 existing seems to grant the probate court more authority when it's conducting its approval. Adequacy being only one.
well, 070, I'm looking here. PR, with the approval of the court, shall have full power to compromise and settle where the claim, okay. Yeah, so that just says with approval of the court. So I guess, do we need that second clause of that sentence? So would it be sufficient just to say the person shall petition the probate court for approval of the proposed settlement?
That's consistent.
Yeah. Okay,
So if we're changing the first sentence,
yes,
to state that the PR can enter into a settlement agreement.
Right.
Subject to the approval of the court, then in the second sentence, it's no longer a proposed settlement. It's a settlement. It's subject to defeasance if the court disapproves it.
Sure.
So it's no longer, it would only be a proposed settlement when it's not effective until you're asking the court to approve it ahead of time. So you could drop the word proposed.
Oh, you're just saying in light of the change to the first sentence, we don't need proposed.
Yeah, but,
No.
I mean, I think the reason this adequacy language is we wanted the court to not rubber stamp. It was part of the reason that we had in giving up on the idea of giving notice to beneficiaries was the court is the person who's evaluating this independently and making this independent determination. And so I think that was the reason for the adequacy, and I think that is the reason, you know, why you use the word proposed, because it's still subject to approval of the court.
And I'm okay with proposed, I think it's just maybe belt and suspenders, but it just says this isn't done until it's done. But the adequacy, what does adequacy mean?
Well, I think that our intent was, you know, taking into account all these factors, is this an adequate settlement? And, you know, the injuries, the insurance amounts, you know, what caused the death or injury, all of those things. And I think the idea was the court doesn't just rubber stamp
Right.
it, the court evaluates.
So let me put the question back to you, Richard, and Shannon, if you want to weigh in on this too. If the court, and I think part of the intent here was to give the court some standard by which to approve or disapprove a settlement. I mean, without some marker, what is the court using to approve the settlement? Why would a court say no?
Because it's not adequate.
Right, well, I mean, so that's, we're trying to create, our point was to create a standard.
That could be one of any number, multiple defendant cases, and some of them are getting, dismissed without paying anything. The court may raise an eyebrow. The amount of the fees being, petitioned, because maybe it was quickly resolved without a lot of complications. That would be another reason to reject it. The court right now, at least in my experience, does a good job of trying to determine whether it's an appropriate settlement under the circumstances. One thing the court, in my experience, has never been able to do is to take 4 binders worth of medical records in a breast cancer case and try to figure out whether life expectancy in this case is going to be short, or whether there's a good chance the defense is going to prevail on it, so that there's no settlement. I mean, there's no recovery. Or go through the depositions that may have been, they don't. That's just not feasible.
And that's why the statement is so important. And the summary would be, the actuary state her life expectancy, whatever.
Whatever detail is necessary for the court, but the court may say, no, I want more certainty about that. That has nothing to do with adequacy, that just says I want more information.
You said appropriate. Would appropriateness be
Yeah, it's better word.
a fair?
Or if you wanted to broaden, you know, the court's subjects of consideration, you could say, in considering, you know, approval, the probate court shall consider the adequacy, something like that.
Or you could say, in
Not
addition
limiting
to the award under ORS 30.070, the court shall determine.
That
In
kind
the
of-
30.070, does not restrict the approval process.
So would appropriateness under the circumstances be a language that at least sets some sort of a standard that everyone can agree with?
Well, but I think his point is, and this is a really good point, is what about attorney fees? Are these attorney fees appropriate in this situation, given all the other things?
See, appropriate.
Right, but that's not the settlement that's appropriate, then the court can say, no, okay, the settlement's great, you just don't get as much in attorney fees. And so we don't want to limit the court to only determining the settlement, we want to allow the court the rest that's in the current statute.
That's the problem with the current statute too. I mean, that only applies to the settlement as well.
You know, since we're slicing it this fine, adequacy can only relate to the overall dollar amount being paid by the defendant.
Right.
And I think Richard made an excellent point. That's just one of the things that the court should be looking at. If the overall amount is fine, but it's all going to the wrong people, that would be something the court may want to weigh in on and might disapprove the settlement for that reason.
I don't think we want to get into attorney fees specifically. I feel like that's just a can of worms. Like, why why should we, you know, pull that out and earmark it specifically? I think it is a factor that the court looks at, but I don't think we need to kind of spotlight on it by itself.
And you can say the same for costs, or you can say for, you know, the liens amount, I mean, who knows?
The amount of.
But right now, in my experience, the court, you know, takes a look at the declaration in front of it and may have some questions, and they could come from any number of directions in the court's exercise of its discretion to approve.
Jeff and Brian, what do the courts want here? Do you want guidance, or do you just want, do we end the sentence with a period after settlement? The court shall approve, or yeah.
And that's what the judge is wanting to hear about, to determine whether this is appropriate or not. Typically, the approval of the settlement is the gross proceeds less attorney's fees,
Sure.
less liens, less costs.
All those things in two.
So the net amount of money to be bigger or smaller than the beneficiary.
Well, wouldn't also a factor be what sort of resources are available? I mean, if the tortfeasor is basically poverty stricken, the caps on his automobile insurance is probably all you're going to get, as opposed to a case where, you know, it was a truck driver for some major multinational corporation where there's a deep pocket. So the court's not just considering the amount, but the
Yeah.
chances of recovering.
And that's addressed, I think, under I, the efforts to maximize recovery. You'd say, we've done a search, we've had them sign an affidavit that they don't have other insurance and they don't have other assets.
For the sub and
Yeah, that too, either one. So are we okay, I'd love to carry this conversation on all day, because we gotta get to the banks. Are we okay ending it just with a period at settlement and then understanding that those factors under two are gonna be what the court looks at? Yes, courts say yes. All right, done. No. Jennifer.
I'm worried about Multnomah County.
Right.
I'm worried about.
Marion County.
Or some little county where they just like, oh, well, I have to approve it, okay, I'm approving it. And so here's some possible changes that could address all the concerns. And that would be, and the probate court shall evaluate the adequacy of the proposed settlement and any other factors the court deems appropriate, or something like that, so that it just makes it clear that the court has a duty to independently evaluate the adequacy.
I'm just gonna say at this point in the session, in the morning, in the meeting, less is more. And we'll pick up Baker County, I guess, later if we have trouble with them. But yeah, I'm just concerned, adding more language is just gonna complicate this discussion, and we need to move on.
So can we put in the comments that the expectation?
Excellent idea. The court will use the factors in two.
Independently evaluate
Sure.
and whatever,
Sure,
you know,
Can I offer more help here?
maybe. Define help.
It's a wonderful to know nothing. Shouldn't M say, explaining why it's appropriate to settle the case in the manner proposed? I mean, it's always appropriate to settle a case.
I don't wanna add words.
That's usually my line.
I know. I'm learning from you. So J, what are we gonna do with J, folks? I think that this does present a problem, certainly in wrongful death cases.
Why not just change two to apply to the PR, not the lawyer? And then it's all solved.
Shannon suggested just deleting the and beneficiaries, which I think addresses Richard's concern, if I understood that.
I hate to have a lawyer evaluating the interest of the estate when the estate really has no interest.
well, you know, but the interest of the estate is if they're creditors, it's the PI case and they're creditors.
Right, so it's a PI case, so that,
Creditors.
yeah, how do we make this,
So that gets Rick in the back door.
I think this is appropriate, the interest of the estate is appropriate for survival action damages.
Right.
I think it's not appropriate for wrongful death, so how do we do that? Marissa, do you have a way to do that? If the claim is for settlement of a personal injury action?
Yeah.
as a personal injury claim is defined.
Yeah.
in Section
Yeah, right, that's that's where I'm going, yeah. So this is limited to personal injury claims. Yeah.
Well, would we wanna then leave that under 2, or would we wanna have a 3 that is things that only apply to personal injury claims, even if it's just that one?
I think, now, given it to be the only one, I think, given that we only have one thing here that seems to be different between the two, I just put the qualifier, the limitation in J.
Okay.
That if this is for a settlement of a personal injury claim as defined, then the attorney's independently evaluated the interest of the estate, semicolon. John,
Not to be a pest,
what?
because I'm reducing the length now. If you add in the manner proposed to M, I think you could delete J altogether. I mean, you could delete, whatever that is, L, J. You can delete J and just add in the manner proposed to M, and you're good. And I saved many words.
I mean, it doesn't call out what that specific thing is.
No, it doesn't.
And in the commentary, you can
Shannon.
talk about why it, explaining why it's appropriate to settle case in the manner proposed. And how could you possibly articulate the appropriateness of the proposed settlement without addressing the interests of all the stakeholders?
Shannon.
And assuming you're trying to maximize recovery, I think that the interests of the estate or the beneficiaries are most likely going to be met. And do we need J if we have I saying the reasons you want to settle and the efforts to maximize recovery? Maybe we can just remove J altogether.
Works for me.
Okay, great.
Anybody wedded to J? Of course, the SLRs can still SLRs can stay, we're not overruling an SLR.
We could.
Oh, Jeff, wait,
Well, I certainly wasn't around with that.
yeah,
But, I think that the judges are looking to get some kind of affirmation from the attorney that they're not overseeing.
No, I don't want to.
So they looked at it and think the other side. So like, I don't know.
yeah, that's M.
Yeah, so I don't know that we.
Okay.
Do that. I think the judges should still be looking.
All right, let's add a comment to that then, that we're deleting J, not with, well, of course, we're not really deleting it because it's not in the law now. But just saying that M would include, what the SLR, considers now.
That's not part of the Multnomah County SOR.
Oh, okay, then Jeff is Clackamas County. Yeah, okay.
That's the most robust of these factors.
That's right, yeah, that's right, sorry, you are, okay, so that, of course, I know that. All right, so we're gonna take out J. Richard, I wanna leave L in, I think.
Well,
Is there a part of
well, I'm gonna,
that we can reference to cover what L's trying to get at? Because if Rick apparently has a claim, and if Rick has a claim, shouldn't that claim exist under some part of the wrongful death distribution scheme?
This also applies to personal injury claims, does that make sense?
well,
Okay, that changes that a little.
Yeah.
I mean,
What?
so, go ahead.
Shannon,
So under G, we're already listing out payments, how it's going to be dispersed. I feel like L is a redundancy. If we're incorporating the rest of the probate code and the personal representative is gonna be subject to that, then they're gonna have to say that all creditors have been located under 115 OL3 when they're, under penalty of perjury, saying that they've located all of the creditors.
I'll be real blunt. I'm sorry, some people are gonna be offended by this, but I don't have confidence that, that due diligence requirement is actually met by a number of people. And that's one of the reasons why, I am trying to get into the statutes, those things which clarify their affirmative duties.
Well, I feel like it is there though, and between 416 and 115, I mean, adding it in another place, is it really gonna change these people who aren't following the laws that are already existing?
I think it is helpful to have it specifically itemized, I do. Because they'll go, if it's specifically listed in there, then they can't, it's harder for them to ignore.
I mean, it is
Now-
specifically listed in that we already have to give notice to DHS. It's requirement of a probate.
And yet we don't get the notices.
Well, then why do you think this was?
Well, I think that.
Because they're gonna have to tell a judge.
But we also have wrongful death claims, and then we also have PI claims, and so liens. And so if we change the language, and Rick had suggested, stating whether the attorney has consulted with DHS to determine if a claim exists. That covers everybody. It gives us that, yes, the state, I will have to agree to a certain extent with Rick. I have.
Of course, you're his lawyer.
And it's not just DHS, it's a number of other state agencies that I represent. Department of Corrections was shocked when I was forwarding them, a group of comments about something that, you mean they're trying to keep from having to pay liens and money that they owe the state? Attorneys are telling and trying to figure out ways to avoid paying the state? They were shocked. And it's like, I'm not, because I've been dealing with DHS stuff for a long time. But the reality is that when you call it out, it does make an extra impression. Don't forget about DHS.
So what we're asking for, and I think what we granted in L, is sort of a special dispensation to DHS by listing it specifically among all the universe of other creditors whose rights also have to be acknowledged. And this is just sort of a special, it doesn't create any new rights for DHS.
I don't think so.
No.
But it elevates the status, it elevates the visibility of your rights above any other creditors.
Yes, and
Because otherwise, all the other creditors are gonna be covered under.
But DHS has those extra special rights
Right.
throughout the
Right.
probate statute.
Okay.
This isn't inconsistent with that either.
All right,
And I object to imposing that on the lawyer.
well, we gotta figure out we gotta make a decision here. Shannon, what are you looking up? Are you looking up the answer? Are you Googling it?
I'm looking at 417.530. I mean, my only concern is, if I remember correctly, that is limited to personal.
Well, and that's why I said we could take that out and just say claim. They've contacted DHS to see if the claim exists. A claim could be a wrongful death authority under Chapter 30, or it could be a lien under.
I mean,
OI.
don't you?
This is both.
If I send Rick notice,
Mhm.
then why do I have to call him?
Because you're
If I
not,
send him notice, then it's on him if he doesn't respond.
but
So now it's not only that you serve notice, but you also have to
And that's
consult
and-
with them.
Yeah, and that's because we want to make sure that there's accountability, and when the judge looks at the document, they see, oh, they did contact DHS.
I think we should.
Don't have to contact any other creditor.
Kathy?
I think it gives protection for like new attorneys. I feel like people who are experienced, they're gonna know that, they're gonna do these things, kind of like with the Medicare reimbursement lien, those types of things, but if the attorney has exposure, I think, like Richard said, it's good to call it out and remind them, oh yeah, I needed to do that.
and there is extra exposure under 540 for the personal injury lien cases.
Okay.
Liability for the.
So, but your language would be consulting with DHS to determine if a claim exists?
Claim against the
I mean, there can't be any dispute. If we pay medical expenses that are related to the
Right. Oh, yeah.
wrongful death,
Sure.
we're entitled to be paid.
Sure, of course.
And we can submit a claim.
And if you have a claim for public assistance, that's recoverable against the proceeds of a personal injury action.
Right,
Right. Not a wrongful death, but a personal injury
right.
action. So,
I mean, I'm hoping that, my thought was, since we clearly have a claim, and we have a right to submit a claim, then maybe that gets beyond the concern about the lien. I don't know, maybe that wasn't what the concern was, but.
Would you mind if I ask what the concern is about stating whether or not there's a Medicaid? I mean, in my experience, your group of members are pretty good about supporting these,
And I've been down the road a number of times, and certainly, had discussions about the scope of the lien based upon case law and, what the asserted lien
Right.
amount should be, so.
Right.
I've been down that road.
And this is agnostic on that.
On personal injury. So here, you're talking about the declaration to just approve the settlement.
Right.
So this is not part of what the probate court should be focused on when it's actually being addressed to approve the settlement in the first instance. So I don't think that it's a proper subject area. We also have all agreed that notice has already been given for purposes of that lien. Now,
Well, I don't concede that point at all.
I'm saying that there is a statutory
Obligation,
requirement.
right.
I heard Ms. Merrill on having to enforce, and, you know, if there's people out there that are going to risk an enforcement action, and, you know, penalties that come with it for not doing what they're obligated to do, that's on them, not on the rest of us.
Jennifer? Oh, Shannon, go ahead, then Jennifer.
So the former SLR did require that the proposed distribution of the settlement proceeds be listed in the affidavit or declaration.
The Multnomah County?
Yes,
No.
it did, yes.
It never got the distribution?
The proposed distribution, disposition of settlement proceeds. I can look that up if you.
I've got it too.
It says, yeah, so it says the proposed disposition of settlement proceeds. And so, at least in our practice, we recommend that the lien be included in the declaration just because the court wants the information. And it's also often included in the petition just because again, from the date of injury to the date of death of settlement, that, you know, the settlement is subject to paying back the debt. So it's part of the distribution which needs to be disclosed to the probate court.
And again, just a question, if I can just answer that one, is you've got the petition to just get the bulk of the settlement approved versus a subsequent allocation petition, which actually now the parties either by agreement or they've gotten their own attorneys and argue about how the allocation is going to take place. So you got two different vehicles going on.
And I think allocation is very frequently a separate motion on its own. And so, yes, I completely agree that allocation of the proceeds should not be included in this initial declaration.
So often, this declaration that we're talking about in the sub two, does not include any initial allocation other than attorney's fees and costs.
So OLA would advocate then that we shouldn't have to miss this position of
The current sub two doesn't include anything about proposed distribution.
Right.
the moment that the large do.
Oh, no, I'm gonna check it, I don't have my ability to do it as an
Yeah.
application.
Okay. But it's not here, so we're not,
Yeah.
we're
So
not,
what's looking at it?
yeah.
Okay.
Jennifer, you want it?
Well, so one thing is, it does say here, stating the amount of payments or reimbursement owed.
Yes.
And I assume that would be a DHS.
Yes.
Right, okay, so it does say that. But how about this? If the concern is the notices aren't happening, take out L and just add a requirement that before the approval, there has to be filed with the court proof of service of the notice to DHS.
That's
Mm.
the Martians, there's already portions of that in
Yeah.
the bill.
Okay.
What about this? We do have there under G, state the amount of payments or reimbursements owed under ORS 300303. Can we just add and, in the case of a personal injury, settlement of personal injury claim, 416,540? Aren't they really a species of the same thing?
Well, what I hear DHS saying, and I wasn't catching this nuance, is there could be claims owed under the wrongful death statute that were as a result of the injury.
But they'd be covered by 3003.
Oh, okay,
Right.
okay.
How about if we do that?
You can add that to.
Add that to G. Payments or reimbursements owed under 300303.
Okay.
And in the case of a personal injury, settlement of a personal injury claim as defined, ORS 416,540. You don't have to
That's in
consult.
your interest, though?
I'm sorry, what?
That raises the issue, but doesn't require consultation.
No, it doesn't occur, you just have to identify it. Which again is for the purpose of educating lawyers who don't know. Okay, we're done.
So,
Remember that, before we compromise.
Yes.
is that a payment owed under 416,540? I'm sorry, is it a payment owed under 416?
I think you could be characterized that,
Okay.
yeah.
Okay.
Okay,
Remove that.
yeah,
416,540 talks about a lien. Could it be the lien rather than payment?
Liens owed,
But you could even notice under 416,530 as a.
Yeah, maybe reference 530 instead, let's see.
so we're going away from my simple answer.
No, I mean, it's changing the statute.
We're all still there.
No, it's changing the statute, and I think that it's.
Overtime.
The idea is, have they given the notice?
So give me your language, in G. Are we fixing G or are we doing something else?
No, we're fixing G, we're just changing the statutory reference from 540 to 530,
Well,
because
but now
530 is
it's not
the
a-
notice.
It's a notice.
Right, that's the problem. It's
Yeah,
not-
we want to know, stating that they owe this money, and I guess it's,
Well, no, they don't.
So maybe it's a new L stating whether the attorney has provided notice
Well,
required under 530.
no, because that's the notice requirement, which is opposed to what, the lien itself is 540, and that's saying,
Yeah,
you have a lien on this
yeah.
amount.
I think 540 stays.
So, yeah, I think that's what,
And it's payments or reimbursement, that covers a lien. Because a
Yeah.
lien
Yeah.
is payable.
Yeah.
Okay. So stating the amount of payments or reimbursements owed under 300303, and in the case of a personal injury action as defined, 416,540.
How can you have a wrongful death action?
That's fine, because
No, we don't.
section is talking.
We don't, okay, sure, okay, all right, sure, okay, thank you. Marissa already fixed that. All right, and I'm serious, Richard? All right. Well, then I've accomplished my first goal. All right. Richard, thank you.
Thank you very much.
Yeah.
Thank you all.
All right, so let's go on. Oh, wait, sorry, wait. I got an email from Claudia Burton. Oh, isn't that just sort of the, let's see. This just came in at the end of the day yesterday, so I didn't even bother to try and get it around. I have one comment, that is a provision for court approval of settlements that states the amount need not be stated. I have a hard time understanding, how I would evaluate a proposed settlement without the amount. That, yes, that's right. That is, it's in the declaration under 2. That's the answer. Yeah.
I think the professor called out.
Judge. Oh, Susan,
yeah.
sorry.
In the report
Yes.
that you had, it indicated that the petition need not include it, but the declaration.
Yeah, and that's the easy answer there.
yeah.
Okay, yep, that's even that. Didn't even consider another reading. Okay, then we are done with wrongful death. Oh, Shannon, stick around for small estates. No, you're fine. No, okay, House Bill 3007. Let's start with first the -2s. Yes, good to see you, Richard.
Thank you, Richard.
Gretchen, are you channeling Matt?
Yes,
Okay.
so,
Anybody need a printed copy? I have it if you don't have your computer like me. Yeah, who does? Kathy and Jeff. What's that?
Are those the amendments?
Yeah, that's good. Okay.
And if you do have a device, if you go to the link and just click on amendments, they are available.
Okay, Gretchen, channel away.
okay, the -2 at page 1, line 4, deletes the provision in the bill that allows the clerk, it deletes lines 6 through 8. And that's the one that allows the clerk to notarize the small estate affidavit, and the question was, I thought the courts wanted that, and are they okay with this change?
Yes.
So like 6 through 8? Page 2,
of the dash twos?
no, lines 6 through 8.
Wait, what are you looking at?
Page 1 of the amendment, referencing page 3 of the bill.
Yeah, oh, delete,
yeah.
okay, so it's line 4 of the dash twos on page 1. Okay?
Bill, here's the dash two.
Okay, yeah.
Very confused when you start talking like that.
I know, it's,
From personal experience.
What's that? What?
No, it's fine.
what is that?
Okay, so it deletes sub 8.
Exactly.
Yeah.
Yeah.
The clerk of the probate may acknowledge upon present, yeah. John, do you remember, this was Warren's?
I probably have that.
Yeah, I'm trying to get this thing up on the screen and it's happening really slowly. What are we talking about?
Language, eliminating the language, the clerk of the court, of the probate court may acknowledge a small estate affidavit upon presentation of the identification of the affiant and the affiant's statement under penalty of
Oh,
perjury.
because the clerk's not necessarily a notary.
Right. So this was Warren's fine point that a clerk is not a notary, but we're not really saying they're notarizing, they're acknowledging.
Yeah, no.
And this is done in, this is done in Marion County, it's convenient for these people, who they've already don't know what they're doing, and then they have to go find a notary, and
Brian, Jeff?
There was an opinion from the state attorney general dating back, I don't know, 10, 15 years ago, that said that courts shouldn't be doing this, and so this was to override that.
He said affidavits are not acknowledged by the clerk or the affiant, is that,
Right.
that's right? Yeah.
Having been in two counties now, that do the opposite. So Clackamas rules acknowledge it, have a clear acknowledge it, all day long. There are pros and cons to those systems, but I'm not sure how much the notary adds to the verification process. And that's why this was brought up.
This saves a lot of trouble for the staff, to recommend in court, when you have to leave and go find a notary.
They're going in and out of security to go find a notary at the bank next door or down the street, see this and that. And then they come back and they didn't do it right, so it has to be corrected, and then they're leaving the building again. It was
Okay,
just an administrative.
I'm fine with it.
Take that out.
Yeah, so we restore lines 6 through 8 on page 3.
And the reason we just wanted to see who they were, to make sure they.
Yeah, right. And- Okay, I'm fine with that. It's not a big deal. What else, Gretchen?
So the -2, page 1, lines 5 through 7, which is
Wait,
page
oh, okay.
4
Page
of
4.
the bill.
Delete
Yeah.
lines 18 through 20, that's sub D.
And that deleted that, and
It-
that said, I believe we chose the more cumbersome language intentionally. I don't recall the specific discussion, but I'm thinking of 2 scenarios. Petition for probate filed and then withdrawn, dismissed. Full probate closed, another asset comes up. The first may be rare, the second may not be a situation that we want to address here. But we just want to make sure there's no unintended consequences from this particular situation.
We definitely had an extended conversation about adding all that language in there.
I'm sorry, what?
There was definitely an extended conversation about adding all of that language in there, and it was added in there because of an assortment of circumstances that various of us were worried about. I would support Matt's suggestion that we keep that language.
No PR has been appointed, there's no pending petition, and the estate is not currently being administered.
well, and the problem with this proposed change is there could be a petition filed and then withdrawn.
Right,
And what we carried out is there either one where there's a personal representative appointed or there's a pending petition to do that.
and if there's a pending petition, it may be withdrawn, but affiant, you have to wait, you stand behind in line until the guy leaves the line, and then you can file your petition. Susan?
And I got an email from Chuck Moritz wondering whether that last clause is needed.
Yeah, it's a good question. It probably isn't. If the personal representative has been appointed, then I think that probably says that it's being administered.
I couldn't figure out what it is.
Yeah,
How else should be administered?
yeah.
Right.
So I'm comfortable with that. Let's take out that last clause beginning with and. But yeah, I'm kind of persuaded that we should leave it in either filed or appointed.
So take out and that the estate is not.
Yeah.
Well, if it's filed and withdrawn,
Then the applicant can file after it's been withdrawn. If it's filed, they have to wait until something happens with that petition.
right, so there's no pending petition.
If a petition has been filed, it's pending.
Yeah, so filed means, if it's ever been filed, the withdrawal doesn't unfile it.
Oh, well,
That's why we have the pending language.
Yeah.
yeah. Yeah, because you're right, filed is an event that will never be
Yeah, got filed.
undone, right. So pending, I think, is the appropriate.
Did we include the administering that last clause because of the possibility of another small estate having been filed?
Oh,
Oh.
Well, that could happen.
ooh, leave it in.
Excellent point, Chris.
Deep think.
Excellent point.
Yeah, good point, Matt. Chris, thanks.
But only if we put something about liens in there.
Yeah, right.
We'll just add to every one of these.
Okay, so we will strike that portion of the -2s and leave the language as it is in the bill. Gretchen, anything else from Matt?
Yeah, the last one was the -2 at page 2, line 15, proposes to delete already existing, this isn't something we added in, ORS 114.540 from the phrase, any other claims against the property are barred, except as provided in this section and ORS 114.540, 545, and 550. We probably feel pretty strongly about this one in particular because 540 includes time for filing claims, time for filing disallowances, and the process. And so, and again, this isn't something new that we added in.
Where are we looking at?
This is on page 12, line 41 and 42.
So it says, as otherwise provided in this section and ORS 114.540, 545, 550, and section 12 of this 2019 Act. Those statutes were already referenced in
We
prior.
didn't add
that in, and Now
540.
they want to take it out. So we feel pretty strongly you still want to have that because of the processes. If you want to incorporate that in for the timelines
Okay,
and other procedural processes.
I'm good with that. I don't,
So we're keeping 114.540.
yep. All right, so
That was it.
does that take care of the -2s? Banks.
What about the new section, on 12, page 2 of the amendments, line 18.
Two of the amendments line, which one? The 112.238 is
Yeah,
amended.
no changes, they put in the word,
Under 113.035.
yeah. Well, and on the next page,
Deceased will.
Yeah, I think his point was there, and I think it's a fine point, but,
Oh,
what we didn't, this is the,
that's the effective.
this is, on page 3, this is the harmless error section. And you may be propounding a will under harmless error, but oddly, in subsection 3 of that, we didn't include will in terms of what you're trying to establish. The proponent of writing described in section 1 may file with the court to establish the intent the writing was intended to be, well, the will. That's one of the reasons you can file it. So I think that was an oversight on our part. Yeah, I think so. So I think decedent's will. And, yeah, and again, this is really more style, I think. On page 2, proponent of the writing shall give notice of the filing of petition under 113.035 to those persons identified in 113.035. I mean,
Yeah, he was saying that there's 2 petitions in here, so, I mean, it doesn't hurt.
yeah. Yeah. Okay, sure, okay. Sorry, that's not on the agenda. What, are you guys having trouble with it?
we're having trouble with that attorney. I've been for years.
So that's the,
Wait, how could they have been struggling with it for years? We just made it up. Huh?
238 around.
112, 238, yeah, it's like almost all
Oh,
around there.
that's the thing, you want to get rid of the whole section.
Yeah. That hasn't been around for years, what, 3 or 4? What? What? Isn't this a harmless error statute?
That's 2 years.
2 years.
Years. Oh, you said you meant 17 years. Okay, moving on. Now we have the banks. Boy, we only had this kind of a deadline at all of our meetings. This was great. Ken?
Well, I too want to apologize for being part of the reason for having this extra meeting. I guess I now have even greater sympathy for all the rest of you. And why won't they talk to us?
Right.
There's a reason. Same experience within the banking industry. I hope everybody has a copy of the amendments that were sent out, and they're much less complicated than they appear to be. These are, that's not it.
You mean this one?
Yeah,
That's right.
this is it.
Yeah.
Everybody got that? Everybody got this? Yeah.
Much of what's on the first.
Yes, 425, or 114, 425, 525, yeah.
Yeah. Much of what's on the first several pages is simply a repetition of what's already in the bill.
Right.
But I want to call out the 4 things that are a change. The first, and this is the list of things that have to be in a small state affidavit. The first, I thought it would be helpful, and I think it will be helpful in getting the banks on board, to put in this provision that would require that there be an upfront notice in the small state affidavit itself that kind of describes the fact that the recipient of the affidavit has to pay or deliver the property. And if they don't do so, there will be hell to pay. Not to go legal. Yeah. So that's what that language is intended to do.
Okay, let's stop with that. Any, yeah, oh, no, I'm sorry, go ahead.
No, that's fine.
Okay, because that's the first one. That's an independent, yeah.
And for those of us who are not good at reading quickly, where are we in the document?
On the first page, lines 6 through 17.
Perfect, thank you.
This would be a notice immediately below the caption,
Bold language.
bold language,
Huge type.
huge type.
Which means they won't read it then, because they only look for the fine print.
Under ORS 114, acceptance of the by law, you are required to pay an affiant any debt you owe, transfer, deliver, access, and priority. If you refuse to pay or turn over, the affiant may ask the court to compel payment. The court may award reasonable attorney fees to the failing party, and the court finds the affiant file a motion without objective reasonable basis, so the person refused to pay. So what do we think about putting that? No, I think the intent, I mean, honestly, I think it could be helpful in getting the attention of a bank.
So I agree, I think it's a good idea to have it there. I think this length, that you think the audience for these small state affidavits, the people that have high school education, this is very confusing. They're not gonna read it because it's so confusing. And I think you could reword it to say, to catch their attention and be a third of the length in big print, and they might understand it.
Of course, we're not trying to get at the affiant, we're getting at the recipient.
Well, that's true, but then some recipients may be,
They're not all bankers.
they're not all bankers.
But you're not having problems with.
That's true. That's true.
Yeah,
They understand it.
I don't know, to me, this is the very start, the first thing you're gonna see is this big notice that everyone buys on the glaze over.
Glaze over or
College level.
get attention.
Yeah.
I have no problem, there's no, concrete around this language. I hear what you're saying, and the shorter and clearer and more precise we can make it, the better. I would suggest we just give it to legislative council.
Sure.
And let them play with it.
Where's
Like she doesn't have anything better to do, right?
Yeah, John.
Fun little break.
Hey, Ken?
Yes.
My first reaction to this was that it might be more visible if it was a separate notice that accompanied the copy of the affidavit, as opposed to putting it in the affidavit itself.
I don't have any problem whether it's separate or part of the affidavit. I was trying to comment
Right.
on paper, but,
Because the affidavit doesn't,
yeah.
it goes to other people than
What's-
creditors.
What's everybody?
I don't know, I guess I sort of like having it all in one document, so the applicant doesn't have to create another document or go get another document.
And isn't the basic point of the small estate to have one document take care of everything?
Yeah,
I think if you just simplify the wording.
If you attach things to the small state application, and attach it to a sheet, you don't do that all the time, it's not helpful.
but in this one, this is the location of it, this puts it right up front. And again, I think I'm okay with that. What?
Oh, just that it's gonna keep the whole presentation.
Right, that's what I mean.
Yeah.
Like, I would be,
I want to report that.
I'd probably be happy with just like a big bold sentence saying, a notice regarding your obligation and rights or is attached to the, well, say that, and then it's just a form notice.
I have a more important point.
What?
It should be on pink paper. Sentence.
Well, you say that it has to be in at least 14-point type, but your form is not all in 14-point type. And it doesn't say anything about having any of it to be all caps, but the form does have some part all caps. Good point. So,
Good.
other than that, it's all great.
Okay, let's mull on that, and let's go on to your other points.
The next point is at the bottom of that page, lines 19 through 21. I found it interesting to discover for the first time that there is no requirement in the small state affidavit to identify the affiant or to provide any information about the affiant. So that's all that lines 19 through 21 is intended to do.
Huh.
Well, that's a sign it, so their name's on it somewhere.
And there is an address for presenting claims.
Yeah, well, again, it bothers me because I went and looked at the form that we use in the
Yeah,
office.
yeah.
And that's the very first thing I have is, I'm an affiant, here's my name, here's my contact information. It just seems
It's
logical.
kind of an odd thing, isn't it? I don't have any problem with that. Okay? Boy, we are
We're-
soft and easy today.
Okay, if you move on.
What do you mean, but you say, what's C, the authority under which what do you mean by that?
Well, just the
Why you
statute.
get to the statute?
Yeah.
There's specific people that are enumerated.
Right.
Right, and that, you're talking about having them identify what their,
What their relationship is?
Right.
Don't you like that?
Well,
Yeah, that's-
take that out, I don't care. I just think the affiant's name and contact information
Yeah.
is kind of important. So if you want to take the authority thing out.
I get what you say, because I've seen next
Kathy?
door neighbors.
Maybe relationships with relationships.
That's,
Well-
you know.
But you might be the PR under the will,
Or a creditor.
or a creditor.
Well, that's relationship.
Well, I mean, I guess, I've never, this is one of these things being broke,
We need to have it, though, because they do have to have a basis for being, I thought that was in here. They have to have a basis for why they are entitled under the statute to be the applicant.
You can state why you are entitled to be the affiant.
Because I'm the POA for the dead person.
yeah.
Believe me.
Yeah, I think that power of attorney works.
Yeah, that would.
So what's the thinking? I see the courts caucusing in the corner.
But that's always been in there, so I thought it was.
I think that clacking thing from always had that.
Yeah.
I was just trying to put it.
Okay, that was in that form that I was, and maybe that was what's added in there.
Interesting.
Maybe Martha and I can
Work on what?
on the
See.
basis that they have for being now.
And then just reference whatever the statute says, you can be happy if you.
Yeah, that one,
Right.
yeah.
Yeah,
Oh.
well, that's what the form
Right,
is. Yeah.
yeah.
What's that? What's the form say?
Well, the
And then
form
I
says,
have the authority to file this affidavit because check and review documents.
All right.
must be checked.
Then in that case, Ken's language works.
Okay.
State the authority.
well, but it gives the applicant who's ignorant the option.
Right, but we don't have a statutory form, so,
Okay, but, okay, well, could we add those options in some way and see?
No.
You could say, state whether the affiant is an heir of the decedent, a creditor,
File a will,
yeah.
the will has only priority.
Yeah, you're right. So, that's right, no, that's right. I think your authority may be just as good as we can get. And the form, I mean, the form already accommodates it. And do most pro ses use the form from the counter anyway? So they're not creating this thing. They have no way. There's 1,000 things they couldn't do if they were creating this. So this just validates what's on the form. Okay. Done.
This is
Oh.
Cleve. Maybe it's worth noting that in 515, 114.515,
Yeah,
it says who qualifies to be an affiant. So it's not just anybody. That's
right.
Yeah, I mean, I'll reference that.
Okay, that's a good, so it points back to 515.
Yeah.
That's a good catch.
So is 525 going to require that the affiant state why they're entitled to
Yes.
this? Okay.
Yeah, under 515 with a cross reference to 515.
Yeah.
Already under.
Okay, and now whenever I see that statute, I'll think, oh, that was Cleve.
I know we didn't get names mailing at us.
Yeah, and affidavit is made pursuant
You might
to,
add an email if they're willing to accept email.
that's in the statement, that's in where to send claims. They can put email in the claims section. So, let's see, the third one on line 21, state the affidavit is made pursuant to, fine. Why not? Okay,
Is there a particular benefit coming from that?
yeah, do you know what the concern about that was, Ken?
Well, it's just made under the small state affidavit or statutes of the state of Oregon. I'm not, again, my main concern was with
Yeah.
identifying a client. I think it's really appropriate to leave C in there. And
Yes.
I think D just, further says that this is all being done under the auspices of that set of statute.
Well, in a way, it's kind of a worse than to the.
Sure,
statute.
a body of law, okay, fine.
Okay, so.
Do you want to add a statement that paper red?
Yeah, right. So was there anything else new in these amendments?
The next thing is on page
Too much, huh?
5.
Page 5.
Page 5.
Oh, yeah, right.
Amendment. The third change begins with line 11, and I've inserted the words containing the provisions required under 114.5.5, because now we've added a couple of things, and I just want to be sure that the small state affidavit to which this subsection 6 applies meets those requirements. The final change begins at line 14 and runs through the end of my amendments. And this provides that if you've got somebody who is non-responsive, you can send them a written demand by certified mail, again, telling them that they have to pay the debt, turn over the property, and telling them that if they don't do so, you can file an affidavit to compel payment or production, and you may be entitled to attorney fees.
So this is the notice before you get your attorney fees. You have
Before
to,
you actually move the court to compel and
Is it
ask.
required?
well, this would require it.
Because it says the obvious made for a written demand.
Oh,
And I think if it's required before a motion, we need to clarify.
Well, it says at the bottom of that page, if the person upon whom the affidavit, the client's written demand was served fails to pay, then they get the attorney fees. So the only way they get to the attorney fees is, the only way they get to the motion to compel and the attorney fees is by going through the 30-day notice requirement.
yeah, because you wouldn't say shall, because they may not, for some reason, feel like it's worth it. Yeah, yeah.
So why require a 30-day wait?
Well, it's simply.
Got to get from the branch to the legal department back in St. Louis.
Yes, Schenectady lawyer to finally get his
Well, but this.
head out of where.
Well, yeah, no, I understand, with a bank, they might need a little time to find out what they're supposed to. But if you got the evil brother who refuses to turn over the personal property and tells you where to stick it, why wait 30 days before you can act?
We could shorten that to 10 days for evil brothers.
Yeah, something like that.
I'm not wedded to that period. It seemed like a reasonably short but reasonably long period of time to get the job done. And what I'm really trying to do.
That makes sense with banks.
Yeah.
Because they aren't that smart necessarily. But you got evil people too, and you give them a 30-day, if you make a demand and they don't turn anything over to you, then you gotta wait 30 days, but it's kind of awkward.
I understand what you're saying. My focus was on getting to the distant authority.
So, I mean, is this a case where we try and compromise on a number, 21 or something like that, or?
Well, there's still a 4-month period. I mean, I think it's just simpler to have 30 days, and I think for banks or financial institutions, it needs to be that long.
I think it should be 31. But,
All right.
There's a lien.
All right, so I guess we can live with that.
So do this?
Yeah. Now, the question I had about this, what? Oh,
Well,
Chris.
just looking at this, it takes away the recovery right that we had intentionally written in here without this 30-day notice. And the intent here is that this is aimed at less educated, non-attorney assisted parties. I can give you a copy of this document and tell you, you have to give me the thing. That makes sense. I have to send you some kind of notice within 30 days. Well, what has to be in that notice? I think adding a 30-day notice requirement, given the intended audience, creates an issue.
Well, doesn't my language say what is supposed to be in the notice? And you don't have to give it within 30 days. It's when you give it, then the recipient of the notice has 30 days.
So you send the affidavit to somebody does the bank. That's the first thing would be, you take it into the branch.
Right.
And the teller reads the policy book and says, nope, I need letters testamentary. And you say, no, you don't. She says, yes, I do. And I say, can I talk to your legal department? No, you can't. So you go back to your office and you draft or you go draft the letter, and that's when the letter goes out.
That's right.
When they initially refuse.
Yeah.
Well,
I mean, or you could just start with the letter, I suppose, but most people won't.
Yeah.
and it might,
You can do
it
that.
might be easier for the person who's trying to enforce this, and the bank says, no, layperson, oh, I can write a letter, rather than, oh, I have to go to court.
That's true, that's true. And then you say, well, write them a certified letter and tell them they have to, and then they go away.
They're gonna ask for the form.
You tell them to call Jennifer, she'll help.
That's right.
For free, pro bono.
You write the
Part of
form.
the issue is that when, Probate couldn't handle it, right? So they had to get counsel to deal with.
Right.
Bank counsel.
Right.
And this gave them a remedy so that it wasn't, a chunk out of the small estate,
Right.
right? So, I don't think we should lose sight of that. If it gets to where you're trying to compel a bank to come in and explain why they were doing your property.
You've got a lawyer probably.
You probably hired a lawyer.
Yeah.
to do it.
Yeah, it's true. If you don't have a lawyer, you're not gonna recover attorney fees anyway. So I guess, that's okay. If you say, you gotta send them a letter. Oh, where's the letter? Well, we don't have a letter. Either prefer to go talk to a lawyer, and the lawyer can prepare the letter.
I can imagine there being a small cottage industry, lawyers, I think their fees at a small state like this are a lot.
Yeah, God bless them. I'm okay with that. But here's a question I had, and this was an interesting question by Mark Comstock when the commission looked at this. In our language on page 6, and help me make sure that we haven't created something here that doesn't cause problems. This is on, okay, it's in this section, starting on line 23, of course, as amended by
Page 6?
Page 6 of the bill, subsection 6, it's just the language, exactly the section we were just looking at, so you could look there if you wanted to. It's a motion to compel payment and then award of attorney fees. In a small estate, we've got, the summary determination, summary review. This is a new thing, and is that okay? And is the award of attorney fees a judgment? And how does it be, do we need to say it's a judgment? How does it become a judgment?
You want to be able to enforce it.
Yeah.
You need it.
Right, so I think this is all very shorthand, but Mark, it was a good question by Mark. How does this work? In other cases, you file the motion for summary determination, you get the order, then you get a judgment through summary review, right? Isn't that sort of the process? But here, this seems to be a sort of one and done kind of motion. And how do you enforce that award of attorney fees?
So you need to enter,
Huh?
you need to add that the court enters a judgment.
Do we? I mean, I feel like we have things like this in other places where it says they're gonna award attorney fees. You might not necessarily have it. I don't know.
And maybe it is. I just want, thought of, and I was just gonna sort of let this go, but since we're all in the room and have an hour, this could be an.
Set of amendments.
Oh, you're a Second Amendment guy, huh?
Writing away.
Ken's a Second Amendment guy. Jennifer.
So if we just said on line 29, the court may enter a judgment to award.
Sure, I guess.
Does that work? I'm looking at the courts. Because this isn't a case, right?
There's a case number.
Well, there's a case number,
It's not considered.
a proceeding. So are you okay that the court may enter judgment for attorney fees? And just do it right in that, I'd love to keep it all in that proceeding, in that one thing. Huh? Okay, I mean, when I say proceeding, I mean the motion. Okay. I don't want to have to send them through summary.
When you file a motion for summary determination, you have the same small estate number, you don't.
Right, okay.
New action.
So then maybe we just need to add,
Well, enter a judgment awarding.
yeah, let's just say that, let's just add that language, then the court shall enter a judgment awarding reasonable attorney. So it's clear.
Are we jumping from
May.
May to shall?
No, sorry, May. But what I want to do is add judgment, so it's clear that the court can do it just on the basis of this motion.
How do you just, not to mention it, how do you just file a motion? You don't have a proceeding.
Well, the same way you do that, just a wink and a nod, same way you do a summary determination. That's the way I see that.
So there isn't a time for filing
Or
objections
PSR.
or time for responding, or I guess in the court with the hearing date, so that's how it.
Yeah. That just goes through your usual, yeah. Okay, let's try that and,
So in
Okay.
my amendment, just to be clear, on page 3, or the last page, page 6, in line 3, it would read, the court may enter a judgment to award.
awarding reasonable attorney fees or something like that, yeah.
I'm fine.
Or may award reasonable attorney fees by judgment to the revealing party, but Marissa will figure that out. Don't you like
How many words
that?
is possible?
Yeah.
So many words.
All right, I just have one other question, Marissa. What was the -1?
I don't know. I screwed something up.
Oh, okay. I just wanted to make sure someone else wasn't trying to muck with our bill. Yeah.
Once we burn the amendment number, we cannot
Yeah,
redo
yeah,
it. So,
yeah.
sometimes
Okay.
it's usually because I screwed something up.
So the only thing that we have not resolved to the nth degree here is the language on page 1 of the bank amendments that Marissa and Jennifer can work with and maybe circulate it. But we're under a fairly short time frame. Does anyone know when House bills have to be worked?
We'll have to have a work session scheduled by April 9th, I think.
Okay, so we got time. Okay, fine. Thanks, everybody. Good work. Isn't this fun?
Fabulous when you get stuff done.
Yeah.
I like it.
Yeah. Good work.
What's that commentary?
Oh, did you want to talk about it?
I don't know,
She's brilliant.
I did send out your comment.
Oh, okay, we got, yeah, Susan, go ahead.
Well, except I closed it by accident, now I've got to open it.
Her comment.
Oh. So my question is whether OTLA is gonna be okay with the bill now, or they still just hate the process, but I guess we'll find out. I think we heard Richard say, good.
I think it has about a 20% survival.
But does OLA have the energy to deal with this right now?
I think so.
No. Last session, at least last time I had partners who were trying to do anything related to OLA had a very one-track mind.
They got that passed
Okay.
yesterday, 2014 passed out of the House yesterday.
Okay, so then they have the energy to create problems now.
I have experienced some energy.
Your first energy.
That thing's passed out of the house every time.
Yeah, no.
So this is where the hard part starts, I think.
Definitely put a good faith effort in.
The politics part.
Yeah.
Whatever. So
Just
one of
frustrating.
his, John, you had a comment on section 10. I had yellow highlighted, now I lost what I wanted to come back to, but I think this was one. I think we need to make a change in the proposed statute about reason for disallowance.
Where's it?
Section 10 of, well, which bill are we in?
2007?
Yeah, 3007, section 10.
Page 8. Of the mark.
Oh, so my,
There was something ahead of that too, but we can start there.
my commentary had said, the affiant must state the reason, which John changed to a reason, and the question was in the bill, because the bill says the reason, and in 2A, 2B says a reason, because there might be other reasons, and he thinks it should be a reason rather than the reason, because there could be multiple reasons, and as long as you state a reason, that should be
Yeah.
sufficient.
And that was the discussion that we had. I think the bill does not reflect our discussion, that you have to give a reason, but you don't have to give all of your reasons for disallowance, because you may not even.
Isn't this language the same as what we did in our probate bill?
Yeah, it should be, right?
Yeah, it's the same thing.
So, that one says,
Our reason, well, yeah, what's it say?
it says a notice of disallowance will state the reason for the reason for the disallowance, and then it's a statement of a reason. It's exactly the same.
Yeah. I'd want it to be the same.
It should be the same in both places, it should be a reason.
Yeah, except, Marissa, what's the,
115.135.
well, we've got the language here in ours, because we just copied it.
Yeah, page 8.
Yeah, I see, they serve different functions.
I mean, I don't really think it matters.
I don't
If
either.
you want to put a reason, I don't see why not, if that makes it clear, because I feel like must state the reason.
It makes it on a pretext.
It does.
Tell us why you reject that, not a reason.
Yeah, right, right.
I don't know why you need to draw one out of multiple.
So, are you saying language is good as is? I do too. We're saying, what's the reason? And then in the next one, we say, whatever reason you say isn't limiting on your ability to raise defenses.
And it doesn't say you have to state every possible reason.
No.
It just says, you know.
Well, that's my worry, that when you say the reason, well, then you've got to identify all of the reasons that you have.
No, you're still gonna litigate it later.
Yeah,
And you have a way to do it.
right,
And
yeah,
it's not an admission, and it
Right.
doesn't preclude
I
the
think,
assertion
yeah.
of other defenses.
right, I think it's fine.
That's the whole point of that part.
What else, Susan?
The other one, I think, and John, all of your other changes to the report, and I was fine with going through. What I was trying to do is target things that were
Related to the bill?
related to the bill. I think section 17, is the other one. And maybe you can describe that. It says, can we improve on the 540, 555?
Oh, yeah, I was real confused by this.
And that was a bill question, or was it my?
That's a bill question.
Yeah, that's right.
Yeah.
And that is in,
It's section 17.
right,
Starts on page 11, but I'm not
yeah, the language is on 12.
on 12.
What's the part that's confusing?
Yeah,
Well,
John-
so 540, deals with presentment of claims. And we have in B, we're adding, except as provided in 550, a claim presented after the limitations described in paragraph A is barred. So that's pretty, without the exception to 550, it's pretty clear that if you don't file a claim within 4 months, the claim is barred. But you've got this exception for 550. And then when you go to 550,
Where are you looking in the bill? Page and line number?
That's the except as provided thing?
yeah.
Yeah, where is it?
Page 7,
Oh,
line 34.
okay,
So we're amending 540.
I see.
Say except as provided in 550.
Okay, line 34 is, okay,
So, but you know, if you ignore the exception, a claim presented after the limitations, described in A, should be limitations periods, but, is barred. So that makes sense, but then you've got this exception for 550. And then if you go to 550.
on page 11, starting on 11.
Is that the?
550 is, you know, a summary determination procedure,
550 summary review.
the summary review. And,
PSRs.
you know, and there we introduced this concept about the 4 months doesn't apply unless the claim was listed as disputed.
So that's the exception that's provided in.
Yeah. So they can file a petition for summary review unless it was identified as being disputed, I believe, is what it says. But don't you want a 4-month cutoff for unknown claims?
How would you do that, with language? Unknown, yeah. Oh, we don't publish in a small estate, isn't that just the risk that creditors take in a small estate proceeding, that?
Yeah, the only remedy they got would be the surcharge against the applicant if they didn't do diligence.
Right, if they didn't, that's right, this is assuming a creditor just unknown and not reasonably discoverable through due diligence.
Well, I'm reasonably discoverable.
Yeah,
Yeah, so you're specialist.
You're special, right?
But if you do your reasonable search and you find
Right.
all of your creditors.
Right, or you think you've
and-
found.
Which you only have 30 days to do, by the way. And you list all of the creditors in the petition. And then you have this 4-month time period that cuts off claims. But then 550 says if you're a creditor that is not listed as a disputed creditor, then you're not limited by the 4-month time period and you can file a petition for summary review for 2 years. So we're not cutting off unknown claims.
Okay,
And I think the problem is the reference in 540 that makes an exception for 550.
I thought the exception actually helps.
I think it damages it. It eliminates the effectiveness of the, so you either have, there's only three kinds of possible claims. Claims that are listed as admitted, claims that are listed as disputed, and claims that are not known.
Right.
So if the claim's listed as admitted, then it's admitted, there's no problem.
Right.
If it's listed as disputed, the creditor has up to 2 years to file a summary review. If it's not listed at all because it's not known about, then the creditor gets 2 years to file a summary review.
Just because it's
So
not
there
known
is no-
doesn't mean it's not reasonably discoverable. The reason that's there, because we don't get listed all the time. We're reasonably discoverable.
Yeah.
You know, the state is reasonably discoverable, and they shouldn't, it's not the unknown, not unreasonably discoverable.
Well, that's a good point, but, assuming that it's not known and not discoverable,
But how do you make that?
you don't get a 4-month cutoff.
How do you define that? How do you break that up?
Well, you gotta.
And is that a problem under the bill or under the current law?
I think it's the 540 cross-reference to 550 that eliminates the 4-month bar. I mean, I don't know of any claims now, the way this is written, I don't know of any possible claims that would be barred after 4 months.
Well, I don't, the except as provided is just a signal to 550. It doesn't create any new.
Well, but it limits the effectiveness of the 4-month bar.
Well, under 550, you can't do whatever is, and you can't do it if you received a copy of the affidavit.
Right.
And you were shown it as the disputed creditor. So that's the 4-month limit there.
Right.
Well, if you get a copy of the affidavit, but you're not listed as, well,
No, you have to have been shown as a disputed creditor.
right.
You just not.
Well, if you're shown as a disputed creditor,
You got 4 months.
you got 4 months.
Right.
But if you're not shown as a disputed creditor, you got 2 years.
Well, isn't that fair though?
Yes.
Because you're not disputed, so your assumption is, okay, I'm gonna get paid.
Not if you're not listed.
Well, no, I'm talking about somebody who's been listed as a non-disputed creditor. You wouldn't file a claim if you've been shown as non-disputed.
Because you're expecting to get paid.
That's right.
Why would you get a copy of the affidavit if you're not on the list?
Yeah.
Yeah, I think so.
I'm just confused as to when the 4 months would ever apply.
If you are listed as disputed and you don't file a claim.
If you're listed as disputed, you've got 2 years.
No, you don't.
Oh, you don't, you're not, you,
Yeah,
yeah, you can't use 540.
right. Okay. Now it's starting to feel like one of our old meetings. I think I'm gonna call it, good. Recognizing that we're never really done, but, this is great, good work.
Yeah, thank you.
Folks on the phone, we're gonna send you away. Thanks for joining us. Meeting's adjourned.